The focus is justice delivery, and to help us get better perspective, we're joined by Owogorga, Emli-Abah, Senior Associate, SG Odey and Associate, Renaissance Chambers. Thank you very much for giving us your time. Let's begin by getting your perspective on the judiciary's performance, especially with regard to election petitions for the 2023 elections.
My perspective on their performance is that I feel a bit disappointed and a bit confused. Disappointed because I expected a different outcome, with particular reference to the Plateau State cases, and a bit confused because there seems to be lacking the crucial element of consistency in most of these judgments that were churned out in this period. I say this because, with reference to Plateau State again, the law is very well settled and has been laid down in a lot of judicial authorities that the issue of the validity or otherwise of the nomination and sponsorship of a party's candidate for an election is a pre-election matter and cannot be challenged at an election petitions tribunal. Now, in Plateau State, the petitions against the People's Democratic Party were mostly that the candidates of the People's Democratic Party were not qualified because they were not validly nominated and sponsored by their political party, the PDP. And like I said before, that the law is settled and has been laid down in a lot of judicial authorities. You can see the cases of APP and Obaseki, Jegede and INEC, and the most recent one of Anionwe, where the Supreme Court says this is a pre-election matter and the tribunal has no jurisdiction to entertain it. There were 3 panels in Plateau State, and 2 panels agreed with PDP to say that these are pre-election matters and the tribunal has no jurisdiction to entertain it. But 1 panel disagreed. That is panel 1 of the National and State Houses of Assembly Election Petitions Tribunal, to say that the question of the validity or otherwise of the nomination and sponsorship of the People's Democratic Party's candidates was both pre- and post-election and ruled against PDP. Moving to the Court of Appeal did the same thing. Now, therein lies my confusion.
If you say that the law is clear, what would you attribute to these variances in the decisions that the petitions courts and the lower courts are giving out? One court will give a different judgment, another will give a different judgment, interpreting the same law. For a layman, it's a bit confusing. If you are perplexed, imagine us ordinary people who don't understand what the law is.
Yes, that's what I'm saying, because it leaves us with more questions than it does answers. Because we have a doctrine in the legal profession, the doctrine of stare decisis, which states that where a superior court, take for example, the Supreme Court, has laid down a principle on a facting issue, every court lower than it would follow, is bound rather, to follow that same principle. But this election season has opened our eyes to a lot of different kind of things. I think I would attribute it to misdirection, or the fact that some of these judges did not understand the facts that were placed before them. That's the only way I can explain it.
Okay, let's look on the other side of the judiciary. And now we have nomination, 11 of them for the Supreme Court. What's your thinking? Will this help with the adjudication that is expected from the judiciary, or do you expect there to be some hiccups on the way to their confirmation?
Oh, well, I think that at the stage where they are now, I don't expect any more hiccups. I expect that the 11 people that have been so far nominated will be approved. I expect that they should be approved, because we are plagued with a situation of insufficient judges. And I think that is why our judicial processes take so long, because the judges are just not enough.
Okay, one suggestion that has been made is financial independence for the judiciary, and I'm aware that the former President Buhari signed a bill on the financial independence of state judiciary. What's your thinking on that as a way to help? Because there are accusations that there are times these judgments are not specifically to the law. Something must have induced some of the decisions. You've acknowledged that there are some of them that just doesn't make sense. So do you think that this financial autonomy will be something that would give some new life to the dispensation of justice in Nigeria?
Yes, I agree. I think that it would give some new life. And here's why. I think that if the judiciary is independent in its finances and in every other aspect, it would deliver its decisions without fear or favor, affection or ill will. If the state executive is not in control of the judiciary's finances, the judges would deliver their judgments without external pressure. They will not have the fear of some form of retribution when it comes to receiving their budgets and all that.
All right, Owogorga, thank you very much for speaking with us. We appreciate your insights.
You're welcome. Thanks for having me.